Picture this. You're sitting in a jail cell, right? You're staring down some pretty serious criminal charges for supposedly causing public disorder through social media. So, how do you defend yourself? Well, most of us would probably scramble to hire a traditional defense attorney and just argue the basic facts. But the scholar at the center of our source material for today's explainer, Dr. Chen Jingyu Wan, took a completely unprecedented approach. He didn't just stand up and argue his innocence. He drafted an absolute masterclass of a defense using complex systems theory, statistical physics, cultural psychology, and semantic philosophy. Okay, let's dive into this and see exactly how one person constructed a multidisciplinary fortress to completely dismantle a legal indictment.
Humans can endure anyhow, as long as they know the why. Now, this quote from psychiatrist and Holocaust survivor Viktor Frankl isn't just some inspiring thought to kick things off. It actually serves as the absolute bedrock of Dr. Chen's entire approach. When you really analyze his text, you realize this legal rebuttal is not just your standard plea for innocence, it's a profound quest for meaning. Faced with the extreme pressure, the isolation, and the heavy psychological toll of incarceration, writing this defense literally became his why. It was a survival tactic. By elevating a standard legal dispute into this high-level philosophical search for truth, he maintained his humanity and his sanity.
I mean, it sounds like a movie plot, right? But today, we're looking at a rigorous, real-world attempt to do exactly this. Can you actually use the hard sciences and cultural analysis to challenge a legal verdict? What we're unpacking today is a brilliant strategy to expose the gaping holes in institutional legal reasoning by applying the unyielding laws of mathematics and the precise boundaries of linguistic philosophy. It's an incredibly bold move and, honestly, a fascinating case study in how we define truth.
To truly grasp how this defense operates, we're going to use 4 distinct lenses as our roadmap today. We'll start with the language of law, move into the physics of information, explore the psychology of resilience, examine a clash of cultures, and then wrap it all up with the ultimate verdict.
Section 1. The language of law, breaking down semantic fallacies.
So the defense doesn't actually begin by arguing the factual events of that day. It starts by examining the fundamental linguistics used in the prosecution's indictment. And this brilliantly illustrates how the defense methodically dismantles the logical structure of the charges layer by layer. It completely exposes a systemic failure in how language is used to assign guilt. They point out logical fallacies where a person's character is attacked over facts and normative misplacements where someone's moral judgment is simply swapped in for a strict legal definition. But to really understand the brilliance here, let's look closer at 2 of the most egregious legal errors they targeted.
The first is what philosophers call a category mistake. The legal charge against him relies entirely on the accusation of spreading false information. But wait a minute, false information must, by definition, be a factual claim that can be proven empirically untrue, right? The defense points out that the prosecution categorized totally subjective expressions, things like political cartoons, theoretical commentary, or just pure emotional reactions, as verifiable facts. It's like trying to measure the temperature of a poem. It is fundamentally absurd. You simply cannot logically classify a subjective feeling as a false fact, which of course completely undermines the entire core of the charge.
Which leads us straight into another absolutely critical linguistic flaw, the failure of reference. In pure logical terms, a statement is a pseudo-proposition if it doesn't refer to anything real. The indictment boldly claims the defendant caused severe public disorder. But the defense counters that there is absolutely zero concrete, real-world evidence of this. There were no specific events, no rioting crowds, no actual physical disruption anywhere. Without that physical proof, the phrase severe public disorder has no referent. Think about that for a second. If the law can punish you for a phrase that has absolutely no physical proof in the real world, where does it end? Legally speaking, prosecuting this is basically prosecuting a ghost.
Section 2. The physics of information, systems and chaos. Okay, here's where the defense pivots brilliantly from language to the hard sciences, specifically statistical physics. How does a single post on social media actually affect society? Now, what's really interesting about this slide is how the defense brings in the fluctuation dissipation theorem, or FDT. This is a cornerstone concept of statistical physics. FDT essentially states that how a complex system responds to a tiny external push depends entirely on the system's own internal structure, its internal capacity for fluctuation. So the reaction isn't actually about the push itself, it's about the state of the system receiving it. To make this concrete for the court, the defense uses this incredible metaphor: pollen jiggling in water. A piece of pollen doesn't move rapidly because it decides to or because it has some tiny internal motor. It moves because the water molecules around it are inherently chaotic and boiling. Now think of the internet as that chaotic boiling water and a single tweet as a piece of pollen. The pollen doesn't create the boiling water, it's just getting knocked around by it. The defense argues that any chaos in a social system is driven by the network's own pre-existing structure. A single external node simply cannot independently boil the ocean.
And they actually back this up mathematically using a model called a branching process. Step 1. An individual with very few followers makes a single retweet. Think of this like a tiny spark landing on wet concrete. Step 2. Because the follower count and the probability of further sharing are mathematically so low, it just doesn't have the fuel to spread. The network is fundamentally in what's called a subcritical state. Step 3. This mathematically guarantees the immediate extinction of the information cascade. The spark dies instantly. By running numbers, the defense proves that an avalanche of information was mathematically impossible under these circumstances.
But beyond all the high-level theory, there's just the raw empirical reality. You see, the institutional threshold required to prove a charge of causing severe public disorder via the internet typically demands 500 or more retweets. 500 is the legal finish line for guilt. The actual number generated by the defendant's specific posts? 0. The defense uses this single, devastating number to collapse the entire legal chain of causation. There is a massive gap between the institution's fear of chaos and the mathematical reality of zero impact. If there's no spread, there's no result. And if there's no result, there is no crime.
Section 3. The Psychology of Resilience, the Mind of the Scholar.
For our third lens, we're shifting inward. How does a human mind operate under such immense pressure without just totally breaking? A psychological evaluation of this text reveals a profoundly structured mind. Most people facing these terrifying conditions would probably exhibit severe stress responses, panic, or cognitive breakdown. Instead, the defendant exhibits high cognitive complexity and what psychologists call post-traumatic growth, where you actually become mentally stronger from the trauma. He maintained high ego integration, meaning his core values, his logic, and his identity remained incredibly stable and intact despite the external chaos closing in around him.
The key psychological mechanism at play here is sublimation. Sublimation is when you take extreme psychological pressure and conflict, and instead of lashing out emotionally or breaking down, you channel it into a high-value, rational, or creative activity. And honestly, here is the profound irony of this whole case. The very institution trying to break this scholar inadvertently forced him into producing a high-level philosophical masterwork. The defense document itself is his coping mechanism. It turns a passive, helpless predicament in a jail cell into an active, empowering philosophical treatise.
Section 4. A Clash of Cultures, When Meaning Systems Collide.
Zooming out a bit, the defense text suggests this case isn't really just a legal battle, it is a fundamental misunderstanding between two completely different species of thought. On one side, you have an open epistemic culture. This is the world of the scholar. Here, information is a playground of ideas, skepticism is a virtue, and uncertainty is perfectly acceptable. On the other side, you have a normative culture, an institutional framework that demands strict boundaries, absolute obedience, and views everything through a rigid security lens, where information is seen as inherently dangerous.
The defense neutrally outlines a broader policy critique here, showing how applying a rigid normative culture to open internet exchanges creates major issues on a global scale. In the normative culture, routine intellectual debate risks being criminalized as rumor. But the analysis points out a major contradiction here. If an institution criminalizes routine debate, it completely disregards digital sovereignty. It isolates itself digitally and fundamentally contradicts its own stated diplomatic policies that actually encourage civilizational exchange and integration with the wider world. So, the crucial point is that this clash creates a massive meaning misalignment. Think about the last time you shared an article online. Were you just exploring an interesting idea, or were you deliberately trying to incite a riot? The defense argues that under this normative culture, the line completely vanishes. The exact same action, just clicking share, holds entirely different meanings depending on the cultural framework applied. To the scholar, it's a cognitive act of exploration. To the institution, it is a deliberate social act of generating risk.
Section 5. The Ultimate Verdict. The Power of Cross-Disciplinary Logic.
This case study acts as an absolute masterclass in using cross-disciplinary logic. The defendant didn't just stand up and argue he was innocent. He used linguistics to break down the fundamental semantics of the indictment. He used statistical physics and mathematics to prove the utter impossibility of the crime. And he used psychology to survive the ordeal. It exposes the profound gap between empirical, mathematical reality and rigid legal interpretation, confronting institutional logic not with emotion or anger, but with unyielding science and philosophy.
Ultimately, this explainer forces us to think deeply about the nature of truth and the boundaries of the law. If a legal and institutional system is built to only recognize one specific meaning, how does it process those who think differently? When a system only recognizes one meaning, is every different thought a crime? It's a question that challenges the very foundations of how we define guilt, reality, and justice. Thanks for joining us for this explainer, and keep questioning the systems around you.